pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. If we could do the roll call, please. Shari?
Haney? Hansen? Present. Montague?
Present.
Murphy?
Barely present.
Ramberg?
Present.
And
Present. And just for the sake of our notes, Mr. Haney did reach out to Mr. Sosowski and I well in advance to notify us of his conflict for this evening. So, all right. Well, the primary purpose of this workshop tonight is to welcome Mr. Brad Banasik, who is the MASB Legal Counsel and Director of Labor Relations for MASB, to Linden Community Schools to help educate and answer questions regarding a variety of topics that we had shared with Mr. Banasik early on, to include general legal, student discipline, social media issues, and just kind of board roles and responsibilities. So I know Brad's got lots scheduled, so we'll turn things over to you. Thank you for being here.
Well, thank you, and really appreciate the invitation to be here tonight, and always applaud boards that bring in MASB for professional development. Feel that's what we're here for, and we're there for, and we appreciate offering that service, and particularly this year, as we were talking previously, you have that $750 credit, and you might as well use it. So I'm glad you're taking advantage of that. So as I go through the presentation, don't hesitate with questions. You can interrupt me at any time. You don't have to wait for a break or at the end. Just if something clarification, or if you have a question on something, just interrupt me, and I'll try to answer that or clarify. If you don't feel comfortable asking that question tonight, you see my contact information. Don't hesitate to give me a call. That's my direct office number. It goes directly to my desk, and if I'm not at my desk, it's forwarded to my cell phone. So generally, I tell folks, if you want an immediate answer, the best way to call me, the best way to contact me is my phone number. Email, I sometimes get behind with the volume of emails, but if you have a question, I need an answer tonight for our board meeting, definitely give me a call. Sometimes on Mondays I'm unable to get through all of my emails. So what are we covering? First, I want to start out with a general legal update. So certainly lots going on, more so at the federal level than the state level, but I do have a few state matters that we're going to cover, and then we'll get into some federal issues. And then from there, student discipline. That will be the bulk of our presentation tonight. After that, some kind of more the governance issues related to social media, and then roles and responsibilities. So, without further delay, let's get right into it. So I want to start out with the Open Meetings Act. Good rule of thumb for me. You start out a presentation with the Open Meetings Act, usually that gets people's interest right away. Because the Open Meetings Act applies to everybody, right? Applying as of right now, being in a public meeting. So the issue we're going to cover tonight is school board committees and the Open Meetings Act, and whether committees are subject to the Open Meetings Act. And you see the three key provisions here under OMA. All meetings of a public body shall be open to the public. All deliberations of that public body constituting a quorum must also take place in an open meeting unless a closed meeting exception applies. And then the other requirement, all decisions of a public body must also take place at a meeting open to the public. So the key term there within those provisions is public body. So clearly, school boards are a public body. When you look at this definition, school board is a local governing body that's been empowered by law to govern your school district. So clearly, by definition, a school board is a public body. The Supreme Court has articulated two pathways to determine whether a governmental entity is a public body. And you see the school board satisfies that first definition, and then a committee would fall under that second definition. The entity is delegated authority from another public body. That was recognized in the court case that kind of initially looked at the issue of whether sub-quorum committees were subject to the Open Meetings Act. So why is this important? Well, you probably have a bylaw that states, any board committee, whether it be a standing committee or ad hoc committee, if that committee is performing a governmental or proprietary function, that committee must conduct its meetings, subject to the Open Meetings Act. So you read that bylaw and you think, well, are committees only subject to the Open Meetings Act? Is it performing a governmental function? And that's what we're going to talk a little bit about tonight, because courts have looked at that issue, and there's a recent Michigan Supreme Court case that has provided further clarification. So you see the second bullet point, if a committee is empowered to act on matters that would deprive the board of the opportunity to vote on that issue, that committee is exercising governmental authority. However, on the other hand, if your committee, again, less than a quorum, so 3 board members or less, gathering information and just sharing that information with the board and maybe tying a recommendation in sharing that information, then that committee is not performing a governmental function, is not subject to the requirements of the Open Meetings Act. And in that case, you could have your committee meetings done electronically. You wouldn't even have to have them in person if those committee meetings are not subject to the Open Meetings Act. But if they are, then you're required to post notice, required to have public comment. You can see the requirements here. Meetings must be available to the public, and you must take minutes for those committee meetings as well. So the case I'm going to cover tonight, this was a Supreme Court case from last year, and there haven't been many Michigan Supreme Court cases looking at the issue of committees and whether they're subject to the Open Meetings Act. I think maybe 2 or 3, and provided a little bit of clarification, but this one, in my opinion, does provides a great deal more clarification for public bodies. So, city ordinance was adopted in response to the initial medical marijuana law that we had in Michigan. Now we have a recreational marijuana law, and still the issue of getting a license for a dispensary is a big issue in a lot of communities, because in this case it was medical marijuana. The community was only giving out so many licenses, and there was a big demand for those. So you see they had 15 licenses to give out and 65 applications. And the city council developed this ordinance, and we're going to establish a review committee that's going to take a look at these applications, and then we'll make a recommendation to the full city council on who's going to receive the license for a dispensary. So the committee held 16 private meetings. None of them are open to the public, and scored 65 applications. They had a rubric, went down the rubric and said, okay, these are the 15 applications we are recommending. There's a lot of discussion, a lot of deliberations in these meetings, but none of them are open to the public. So they refer these 15 applications to full city council. City council said, looks good, we approve, and they move on. As you imagine, the unsuccessful applicants, but wait a minute, how do we know? What went on here behind closed doors and how these applications were scored. So they sued the city of Warren, claiming that that committee was a public body and its meetings should have been open to the public. And the Supreme Court agreed, held that the review committee was in fact a public body, even though its authority was limited to just making a recommendation. It still made an actual decision. So you see that second bullet point, it effectively decided which applicants would receive the licenses. And the city council, it didn't do any of the work. Basically the review committee did all the heavy lifting, and thus that committee was making the decision, and the review committee simply rubber stamped that. And even though the ordinance said committee was making that decision, effectively the review committee made that decision, and that committee should have been subject to the Open Meetings Act. You have a question?
Hey Fred, quick jump in on this question about whether a committee is considered a committee of the whole or a committee with authority or whatever.
Yeah.
We had a situation where we utilized a body of 3 in the most recent negotiations for our superintendent's salary.
Okay.
And that recommendation was brought to the board for full approval, obviously.
Mm-hmm.
Is that considered something that should have been probably an open meeting?
before I address that, let me finish this.
Okay.
And then at the end, I have key takeaways from these cases, and we'll apply those key takeaways to that example, okay?
Okay.
So the analysis focused on not, how the committee was identified. It was identified as a review committee. That says we're not making decisions, just reviewing the applications, and the city council was going to make the decision. The Supreme Court said, doesn't matter what you call that committee, if that committee takes action and deprives the action from the governing body, that committee is a public body subject to the Open Meetings Act, regardless of what you call it or what type of authority it is. So the emphasis in this case is what the committee actually did, and it determined that it made a decision. So key takeaways from this case and other cases: if you want your committees to be truly advisory and not subject to the Open Meetings Act, so in that case, we're not hosting our meetings, public not invited, not allowing public comment, not taking minutes, and maybe you're even having these committees by virtual means. You identify preferred options, recommend them to the full board. All options should be considered by the board, and then the board can either accept that recommendation or reject it. The board ultimately retains the authority to make a decision. That makes the committees truly advisory. They're not performing a governmental function in that case. Committee will likely be subject to the Open Meetings Act if it engages in the practice of narrowing down or eliminating options that never get before the board. So an example of that would be, let's say you created an executive committee to establish board meeting agendas. And this executive committee takes a list of 20 issues and narrows down the issues to 5 for a meeting agenda. And none of those other issues come before the board. That's been found to be performing a governmental function, and that type of committee would be subject to the Open Meetings Act. Now, was the board approval simply a rubber stamp? Always good to have deliberations, regardless of what is being recommended to the board. And then lastly, function is determinative, not title, and that's what the analysis focused on in the Brook case. It was meant to be a review committee, but it actually made a decision on those license applications. So, and going back to your question, Steve, you look at the takeaways up there. Was that committee just gathering information on the compensation, different districts, surrounding districts, pupil counts, taking that and then making a recommendation back to the board, where the board ultimately approved a salary for the superintendent?
Well, typically, the responsibility of determining a contract for the superintendent is generally left in the hands of the board president. It doesn't go beyond that point. In this case, it was determined that they should expand it, add a couple more voices or whatever.
Yeah.
So it became a group of 3 that brought a product to the board for approval.
Okay.
The board did discuss it a little bit. So I guess we did have the option of, let's change it to this, to that,
Yeah, I mean, what's difficult for me to answer that without being, at that committee meeting and knowing what was discussed.
Right.
And whether certain things never made it to the board. That's what a court would look at. Was that committee somehow making a decision by depriving issues to come to the board? Now, if you're just focusing on salary.
Well, it's a whole package. It's salary, it's benefits, it's time off, it's all this. It's all built in.
Yeah.
The bottom line is, the president would, if they just did it by themselves, would they have to post that meeting?
That's a great question, and there is a case pending for the Michigan Supreme Court that addresses that very issue.
So stay tuned.
Where a board authorizes an individual to do something on behalf of the board. That case determined at the Court of Appeals level that individual was performing a governmental function on behalf of the board and could be subject to the Open Meetings Act as an individual. Now, to me, that is a crazy decision, a crazy result, because you look at Well, and we'll be talking about it tonight at student, in the context of student discipline. The board has to delegate, who's responsible for short-term suspensions, long-term suspensions, expulsions, permanent expulsions. That's all delegated by board policy to either the administration or the board maybe retains authority for permanent expulsions. Based on that analysis, someone could make the argument a principal just conducting a quick rudimentary hearing that we're going to talk about a little bit later, and suspending a student for 5 days, that could be subject to the Open Meetings Act. Now, I think that's a ludicrous result.
Right.
But the way these opinions read and how they're trending, someone could make a legitimate argument that that type of meeting could be subject to the. I hope we don't get to that point.
Right.
And I hope the Supreme Court does something with this most recent case to kind of put the brakes on a little bit and say, no, it has to be a committee. It's really difficult, to say an individual is a committee and a public body for the purposes of the Open Meetings Act. But we'll see what that decision says.
One last comment on this one.
Sure.
You mentioned board policy seems to be the thing that governs everything.
Yes.
Okay, so my question or hope to get out of this meeting tonight was how much flexibility do we have as a board to create our own board policies? Because it seems like we get all this stuff from Neola, and then we just look like, oh, you gotta prove it, gotta prove it. Well, that's not necessarily true, because we have gone against it on rare occasion. Partially because we feel bullied that we can't go against it.
So, I guess toward the end of the presentation, we'll look at roles and responsibilities and some of the board, authority, what you have. We'll kind of get into that question, during that discussion.
Thank you.
Any more questions on committee cases? All right, well, let's get into some federal law issues. So before I kind of get into the specifics of some of these issues, I just wanted to give you an overview of federal administrative law and why, there's so much kind of controversy with what's going on at the federal level. So, 3 branches of government, federal level, executive branch, judicial branch, and the legislative branch. So you have your separation of powers, theory between those 3 branches. They each kind of act, individually with their own individual authority. And the responsibility of the federal branch is to implement and enforce laws. Okay, so legislature establishes those laws, or Congress establishes those laws, and then it's time they're interpreted by the courts at federal level. That would be federal district courts, and then Court of Appeals throughout the circuits of the United States, and then eventually the U.S. Supreme Court. So federal agencies cannot act unless Congress has delegated the authority for them to do so, and they must not act beyond that authority. They're subject to a body of law called the Administrative Procedures Act, which provides judicial review of the decisions by the executive branch. And that's what's been going on for the last 3.5, 4 months, okay? Where you have decisions being made at the executive level, and the issue is the executive branch, is it complying with the Administrative Procedures Act? Is it legislating rather than implementing and enforcing? And that's what a lot of these cases involve, is whether the executive branch is exceeding its authority with some of these executive orders that we're going to be talking about tonight. Okay, so that's just kind of administrative law in a nutshell. Now, with your executive orders, they're not quite an administrative rule. It basically provides direction to the executive branch on developing possibly future administrative rules. So they're signed, written, and published directives from the president that manages the operations of the federal government. But just like administrative rules, those executive orders are subject to the Administrative Procedures Act as well. Meaning that executive orders cannot be arbitrary, capricious, cannot be abuse of power, can't go beyond the scope of authority that's been given to the executive branch, and they have to comply with the Constitution as well. And if they don't, that's when the courts step in, okay? So that's federal law in a nutshell. Yes?
So when, I tend to agree with the synopsis of what you're saying. However, I'm confused because the last administration, we followed his executive orders,
Sure.
especially when it came to masking the kids,
Mhm.
vaccine mandates possibly for our staff at the time. So why was not this a thing a few years ago? Like, why did not MSAB come and do a workshop like that back then?
I can't answer that question. I can tell you, most of the requirements that were being applied to school districts were at the state level, not at the federal level. So districts were answering to state executive orders. And state executive orders are quite a bit different than federal executive orders.
Okay.
The state executive orders were being implemented because of a health emergency, which they were, under law. Those executive orders could take the force of law under that health emergency. But for the most part, districts were not subject to any federal laws. Now there have been, during the Biden administration, there were executive orders and there were rules that have been challenged, and they have been struck down by courts. Just like the current administration's rules and orders are being subject to challenge as well. So one for the FLSA, the Fair Labor Standards Act, on increasing the minimum salary that someone would have to receive if they're going to be exempt from the overtime laws. And that was going to skyrocket up to over $50,000 this year. And a court ruled that down, saying that the Biden administration didn't have the authority to issue that law. That was going beyond the authority. So it happens in all administrations. Not just this administration, goes back to the Biden administration, probably happened to the Obama administration. I hope that helps.
No, it does. Like I said, I'm just wondering why, all of a sudden, did you guys do any workshops like that in the last 4 years, 6 years? Or is this a new thing that we're chartering into with MSAB?
There have never been so many executive orders that impact education. And that's the reason why I'm giving you an update right now.
Okay.
So Title IX litigation, another example of a administrative rule that was being challenged. And this was the administrative rule for Title IX that expanded the definition of sex to encompass sexual orientation and transgender. And the court in this case ruled that the Biden administration didn't have the authority to expand that definition and struck down the 2024 Title IX regulations. And the Loper Bright Enterprises case that you see there, that was a very significant decision. That was a decision that was issued last year, and what that Supreme Court decision did is take away deference that was given to executive agencies, okay? Previously, under the Chevron doctrine, executive agencies were given deference by courts, but the U.S. Supreme Court said no, that's akin to the executive branch legislating or interpreting law. And that's not the responsibility of the executive branch. The responsibility of the executive branch is to implement the law and to enforce it. Okay? So establishing that a regulation that expanded the definition of sex to include sexual orientation and gender identity, court found that went beyond the executive branch's authority. So as a result of this, the 2024 regulations were vacated. Now, it's worthy to note that this decision does not impact any other federal court decisions that have looked at this issue of whether Title IX could be interpreted to include, have the definition of sex include a gender identity and sexual orientation. So that issue is still on the table, okay? This is just the kind of a procedural matter, vacating the 2024 regulations because the Biden administration exceeded its authority in issuing those regulations and expanding that definition. So your policy should now go back to the 2020 regulations. School staff should be trained. If you have new staff members who were not trained on those 2020 regulations, they need to be trained on those 2020 regulations to ensure that you have compliance. Now, as a result of that decision, the U.S. Department of Education, so that's what that acronym is, USDOE-OCR, that U.S. Department of Education, Office of Civil Rights, issued a response to this ruling and determined that it agreed with it, and it was going to keep the 2024 regulations vacated, and it was not going to appeal. What's interesting though, when that decision first was issued, I thought that you would still keep your 2024 regulation policies on the books to address any situation that occurred during that time when they were in effect, but that's not the opinion of OCR. Even if you had a sexual harassment situation that occurred while the 2024 regs were in effect, you're still going to apply your 2020 regulations. So your 2024 regs no longer applicable. You want to make sure you're following your policies relating to the 2020 regulations. And then lastly, the OCR referred to an executive order issued by President Trump defending women from gender ideology, extremism, restoring biological truth. The federal government ordered all agencies and departments. So again, this is a directive to the executive branch that we're going to enforce any type of gender discrimination laws based on their only two sexes, male and female, and they're not interchangeable. And OCR said that is how OCR is going to interpret Title IX going forward.
So with what's going on in Maine currently, what's your take on that as far as?
So I was gonna cover that after I cover this
Okay.
piece on Title IX.
We'll wait for it then.
All right, so why all the controversy with Title IX? Well, because when you look at the Title IX law, there's just not much to it, right? You have three elements to it. Can't have discrimination on the basis of sex and education programs, activities, and the entity is receiving federal financial assistance. So you see kind of the paragraph there in total. And the big issues here are the big questions. Does Title IX's prohibition on sex discrimination include discrimination based on sexual orientation and gender identity? And has this issue been squarely addressed by the U.S. Supreme Court or the U.S. Sixth Circuit Court of Appeals? Okay, so we know OCR's position on this at the NAPA. So if you get, so if you're allowing a male athlete to participate in a sport, in a female sport that the male athlete identifies as, you could get a complaint, and that complaint would be investigated by Title IX, and if you didn't change your practice on that, they would, say Title IX violation. That's quick. What we don't know is how a court would rule on that. Okay, we know how OCR would rule on that, but we don't know how a court would rule on that. That's kind of what I'm going to talk about next here. So the Supreme Court has issued a decision in Title VII, saying that Title VII does prohibit discrimination based upon someone's sexual orientation or gender identity. Because it prohibits discrimination because of sex, forbids an employer from firing an individual because that person is gay or transgender. Okay? That was Title VII. The Biden administration said this case should apply to Title IX. You can imagine the Trump administration has changed direction on that, saying, no, this case exclusively applies to Title VII, does not apply to Title IX, so we are not going to apply the analysis of this case to any Title IX issues. Okay? We have a Sixth Circuit case that has addressed the issue of bathroom use based upon someone's gender identity. Occurred in 2016. So that was before the Banasik case. It was before a lot of this really became a big deal. And in this case, you had a student who was a male, biological male, identifying as a female, wanted to use the girls' restroom, and the district court said yes. Title IX requires the district to accommodate that student, to allow that student to use the girls' restroom. The school district didn't want that, wanted to keep bathroom use based upon biological gender, so it challenged that decision and appealed it to the Sixth Circuit Court of Appeals, which is, covers Michigan, Ohio, Kentucky, and Tennessee. And during that time, they wanted to have an injunction issued to go back to the status quo of denying this girl or this student the opportunity to use the restroom of their identified gender, and that's what this case addressed. And the Sixth Circuit denied that motion for stay, so claiming that we weren't going to go back to the status quo. This student is still going to be able to use the restroom of their identified gender. You can see the reason here in the analysis. Focused on sex stereotyping based on a person's gender. That's impermissible discrimination. Also said, the public interest is served anytime you're protecting someone's constitutional and civil rights, and the overriding public interest here lies in the firm enforcement of Title IX. Some courts have followed this analysis. This is going to be a significant case. Dover, Bethel Local School District Board of Education, keep an eye on this one. It did adopt the Dodd analysis, and now it is pending before the U.S. Sixth Circuit Court of Appeals. This case will provide a great deal of guidance to Michigan school districts. Oral arguments have already occurred, so we're just waiting for a decision that will provide us with additional clarification. And then you have the Elliott Larson Civil Rights Act. I'm sure you're familiar with that amendment. Went into effect last year. Expanded our Civil Rights Act to include protection based on sexual orientation and gender identity. It followed a Michigan Supreme Court case that interpreted the act without those protections, interpreted sex to cover sexual orientation, not gender identity at that time, but just looked at the protected class of sex to cover sexual orientation. Even though the court didn't expand its analysis to cover gender identity, the actual legislative act did, and you can see how it now reads: prohibits any discrimination based on age, sex, sexual orientation, gender identity, or expression, height, weight, familial status, or marital status, and see how those terms, gender identity or expression, sexual orientation, are defined. So that's where we're at right now. That's why a lot of states are in a little bit of a quandary, and I'll answer Steve's question about Maine now. Maine has a similar Civil Rights Act as Michigan. Sexual orientation, gender identity are protected classes, and they were allowing transgender athletes to participate in these sporting events or on teams that they identified with. And now they've been found to be in violation of Title IX, and the Department of Justice is involved in the process of likely penalizing Maine from a federal funding perspective. And that is going to be the big case that likely will go to the Supreme Court, that will clearly provide guidance on Title IX. Won't necessarily provide guidance on our Elliott Larson Civil Rights Act. Some states will still be put into that difficult situation of determining, well, should we comply with state law or federal law, and that's when the analysis of federal law superseding state law could come into play.
So,
yes.
Right.
Mm-hmm.
So in Maine's case, you're talking about a penalty, a financial penalty, is what I've heard about. Why is it appropriate to have a financial penalty for actually a criminal penalty? For what happened was criminal. Why can they excuse it off and go, well, we'll just slap you with a fine and you can keep doing what you want to do?
Well, I don't believe it was criminal, in fact, letting
It's not
transgender
considered,
athletes participate in the sports of their identified
that's
gender.
not considered criminal,
No.
according to Title IX.
Yeah,
That's
according
not
to Title
considered
IX,
criminal.
not criminal. There would have to be something in the federal criminal code.
Is it considered civil?
Or state criminal code,
Is it
yeah.
considered a civil crime?
No. I mean,
So it's really kind of the
reason there's a penalty
it
is
means nothing.
because,
Title IX means nothing, so you're telling me.
no, it's tied to federal funding.
Okay.
So the reason that school districts are subject to Title IX is that they're receiving federal dollars.
But we
If
know
you don't
most
comply
of
with the federal law
Right.
as a school district, you could have those federal dollars taken away.
Right.
Yeah.
Well, we know that most of our funding does not come from the federal government.
That is correct.
So,
That's
so
why you may
school
have.
districts and states can say, well, whatever, you know. Is it gonna be the individual districts that get punished on something like that from a funding standpoint, or will it be the state? Cause it sounds like they're heading like.
It may well be the state.
Which is weird. Why is
Because
it
the
just the
state has
districts that
taken
allow this?
the whole position. Now, in Michigan, we haven't taken that position. Now, we have the High School Athletic Association, which is not a state actor, so it's not receiving any federal dollars. They've taken the position that we are gonna comply with LA Larson, and we are going to allow for waivers to allow a student to participate. The High School Athletic Association, they have a rule that says, male athletes cannot participate on female teams. If you're a male, you cannot participate on a female team. But they have an exception to that rule, that if you are a transgender student, you can apply for a waiver that allows you to participate on that female team. And they have decided to continue that waiver application.
Okay, a couple more comments real quickly.
Sure.
I was in Rock Financial this fall or winter for the Michigan State tournament game, and I went to use the bathroom, and they had the women's bathroom clearly identified with the women dress signal, and then over here you had the male, and then you had the transgender attached to the male bathroom.
Okay.
Why was the transgender not also attached to the female bathroom?
I have no idea what
Okay.
Michigan State would make that.
No, this is Rock Financial, this is Ohio.
Oh, this is Ohio. Okay.
This is Ohio, don't blame Michigan State.
All right.
No.
Sorry.
I haven't seen anything stupid like that down there. Yeah, I'll say. But, okay, so there's that question. About the idea of cross competition. It's been appropriate and allowed for females to participate in male sports such
Yes,
as
undeniably.
football
Yes.
and wrestling.
Undeniably.
Why is
Yeah,
that
yeah,
appropriate?
that's
Why is
correct.
that considered appropriate? Because there have been athletes that have found it uncomfortable, especially in the wrestling arena, to participate against the female.
And it's just there hasn't been a legitimate interest cited to prohibit, say, a
So-
female athlete should not participate in
So
male
if
sports. Every case that's went to the courts has sided with the female athlete.
If an athlete had a Christian belief that that was not appropriate for him, a male, to wrestle a woman on a wrestling mat, and that would not be enough to say that I have a claim here, I should not have to wrestle this person?
I think that claim has been made and it hasn't been substantiated.
Wasn't it more about the fairness of it, of the athletic ability, of the strength of a?
Yeah.
So
I mean,
that's why,
but-
it's more
exactly.
about, so that you're not losing scholarships, trophies.
Sure, that's the argument from the side of a male, biological male
Yes,
participating.
the competitive
Steve
fairness
was
and then
making the
access
comment
to
about
scholarships
a
and
female
titles.
athlete.
It just
participating.
creates a slippery slope when you allow it on one side of the coin and not.
But
the
it's
other.
been going on a while.
Well, I know it has, and it's been uncomfortable. I've heard of athletes, basically quitting a state competition because they had to go against a female. They would not charge.
That's their choice to do that.
Well, I think they'd be
It
embarrassed.
cost them a state championship possibly.
I think
Is
they'd
that-
be
is that
embarrassed
not-
if female booked them, that's why, I mean,
Oh, okay.
not saying, I'm just saying,
Okay.
or maybe not wanna touch a.
All right, well, I'm gonna move on here, okay?
Yeah, let's move on.
All right, so, dear colleague, this was issued on February 14th, titled Ending Illegal Discrimination, Restoring Merit-Based Opportunity. So in this case, the Office of Civil Rights pointed to a recent U.S. Supreme Court case, Students for Fair Admissions versus President Fellows of Harvard College. This Supreme Court case, we'll get into it a little bit, but generally indicated that Harvard in North Carolina, this is a consolidated case, was discriminating based upon race when they were using unfair race-based admission policies. Okay, so that case is being now applied to Title VI. You see the content of Title VI, no one in the United States shall be discriminated against based on race, color, national origin. And the court case there wouldn't have happened in Michigan, because if you're familiar with our state constitution, was amended in 2006 to prohibit any type of race-based admission policy. Okay? But this is what was going on in North Carolina and Harvard, and the Supreme Court said, no, these race-conscious processes do not meet the strict scrutiny as required by our Equal Protection Clause, and thus found these these type of admission policies to be discriminatory based upon someone's race. So, relying on this court case, the Dear Colleague letter, both school districts, they would be at risk of losing federal dollars if they're treating students differently based on their race to achieve nebulous goals such as diversity, racial balancing, social justice, or equity. So, DEI, this is the Dear Colleague letter focuses on the diversity, equity, and inclusion, and whether that constitutes discrimination or not. The program stigmatizes students who belong to a particular group based upon proved racial stereotypes. This is the language in the letter that denies students' ability to participate fully in the life of school. That's discriminatory, as determined by the Office of Civil Rights. And again, this would be tied to federal funding. If a school were to be in violation of Title VI because of a DEI program or policy, it would risk losing federal dollars. So the letter concluded, school districts, you have to ensure that your policies and actions comply with existing civil rights laws. That would be both Title IX and Title VI in this case. Cease any effort to circumvent the prohibitions on use of race by relying on proxies or indirect means to accomplish those ends. And then end any third-party contracts that are discriminatory as well. And then at the end, it said, anyone who believes that a covered entity is unlawfully discriminated based upon race may file a complaint with OPR. So now there is this portal for parents, teachers, and students to file discrimination complaints. And this will go directly to the Office of Civil Rights, and if they receive this complaint, they may begin an investigation on whether a district has violated Title VI based upon a DEI practice or policy. Response from our state, this is a Michigan Department of Education memo that was issued February 27th. And as you can imagine, state superintendent disagreed with this Dear Colleague letter, said that a lot of school districts' DEI programs are important. They're not giving advantage to one student over another. It's a zero-sum practice where everybody is winning, not just a certain group of students. So that's how the state superintendent kind of supported DEI programs in Michigan. And then as a follow-up to the Dear Colleague letter, we had these FAQs that were issued. I just selected a couple of questions here that address DEI programs. Question number 8 in the FAQs, are DEI programs unlawful under that Supreme Court case we looked at, or referred to? And does the Dear Colleague letter mean that students, teachers, and school employees may not discuss topics related to race or DEI under Title VI? So how did the questions answer that? Well, the Office of Civil Rights said, we're not going to base a decision upon whether the terminology is used, such as diversity, equity, or inclusion. School districts can still have classes and programs that focus on particular cultures and heritages. They can have studies that emphasize Black History Month and International Holocaust Remembrance Day. Those are okay, okay? But when districts are considering these type of programs, are they discouraging all members of certain races from attending, or excluding or discouraging students of particular races from engaging in those events, creating a hostile environment based upon the race where students participate? Then the question to number 9, the Office of Civil Rights, recognize that they're not going to be involved in controlling school district curriculum. That's still a state function. The federal government is not going to be involved with that, and there are still First Amendment rights of students, staff, and faculty that must be protected here. It's going to be very factually specific on certain programs of whether DEI policy or program violates Title VI. And after reading the FAQs, my thought is that Office of Civil Rights is more focused on post-secondary ed rather than K-12 education based on those FAQs. But then you have this, the Title VI compliance certification, which is the most kind of recent issue that districts have been addressing in terms of, possible discrimination under Title VI. So school districts didn't receive this. This was only received by state education agencies. This was an email sent to all states requiring certification that school districts and state education agencies were complying with anti-discrimination requirements and were not using illegal DEI practices. The email included a document that summarized the legal obligations for districts under Title VI, and see how that is titled there on the overhead. And then there was a 10-day time frame for state education agencies to respond and provide these certifications. It was subsequently extended to April 24th, so that's still 10 days away now. And then the Department of Education issued its response to this request on April 10th, and this is the response to summarize. NDE believes that it has already provided the requisite guarantee that has complied with Title VI and other discrimination laws. Not aware of any legal authority that allows the executive branch to require this type of unique certification, and then also indicated that the 800 local education agencies in Michigan have all certified their compliance with Title VI. So ultimately, NDE is not expecting any Michigan school district to submit their certification form to NDE. So at this point, we're kind of in a holding pattern for local school districts. Some states are saying they're going to do it, other states are not. Along with Michigan, I think Minnesota, New York, Maine, Massachusetts, those are a few other states that say we're not certified. Yes?
I have a question. So if a local school district wanted to certify this, could we certify this?
Certainly, yes.
Because, I'm new to the board, it's new.
Yeah.
But I was at a GIC event and the president of MASB was there and he said, right in front of all of us that were there, we're gonna go ahead and keep doing DEI. We're not gonna put it on blast like on a billboard, but we feel that we should still be doing DEI.
Okay.
And I made a comment that is very irresponsible, basically to the whole GISD. So I think that we're picking and choosing sides. And I think teaching high schoolers, staff, that we can ignore some executive orders of one party and not the other. This is just teaching student, staff, everyone the wrong way to do it, whether it gets set out of court. I don't think this administration is playing. He specifically said K through 12. If you watch what he said, and they're not playing, and I don't want to risk losing money. So if the Michigan Department of Education wants to do it, that's fine. If we are a local school board, if we want to be proactive and do it, I think that would be great. Because I just watched Heartland, and they got in trouble with the DOJ. And I just watched their school board meeting, and they are basically complying with everything they're asking.
So I thought James wasn't talking about DEI in schools. He was talking about MASB's DEI class that they have.
Okay.
They're not advertising that class right now. He wasn't talking about schools.
Yeah.
He was talking about a course that
So-
MASB offers.
And
I will disagree on your interpretation of what you heard. Now I heard it, and how members came up to me afterwards privately and said that they agreed with me.
Well, that wasn't his intent, I accuse.
Well, there might have been a miscommunication, but I heard clearly.
so,
what you said.
it's important to understand here, the Office of Civil Rights has even indicated, we're not saying all DEI programs violate Title IX.
Right.
Okay, so you have to look at the specific class or curriculum or program or event, whatever you want, whatever it is, and whether it discriminates based upon someone's race.
Right.
So just, saying that you should eliminate all DEI programs because that's what, the executive order doesn't say that. And that's what those FAQs emphasize, is that we're not going to say something discriminatory just because it's identified as, furthering an interest of diversity or equity or inclusion. But if the purpose of it is to create a hostile environment for someone based upon their race, yes, then that's discriminatory.
I don't know, I guess from what I watched, but I follow directly what they're saying. They're not saying teaching like Black history and things like that. They're saying any.
And people could say teaching Black history is related to DEI.
Right, but they have specific examples.
Right, in the FAQs. And yeah, those examples are pretty frightening that they use in the FAQs. And yeah, I don't think I would want that, You know,
Well, that could
as
be
far as
your
being taught to
interpretation.
first or second graders, an example they give in
Right.
FAQs.
Right, so it could be up to interpretation, so we as local school districts have that, we can kind of shuffle through what we think our community would consider this or that, and make policy how we want it.
I don't think at this point there would be anything to be gained to doing that. I mean, because it's the state, education association that's responsible for collecting the certifications. I mean, that's, you know, that's what it indicated. So if you could send it to the state, but I'm sure they wouldn't, at this point, they probably wouldn't do anything with it.
Okay.
Any other questions on
But
that?
individual districts are allowed to basically set up the environment of DEI that they want to be allowed in their district?
If they think that it's going to support students and help all students, for sure.
And
And
so
that
it
was
could be-
Dr. Rice's statement, that if DEI is a zero sum, rather than benefiting some and not others, then yeah, it's discriminatory. But if it's benefiting everyone, well, why wouldn't you wanna do that?
Did
Yeah.
Dr. Rice just retire? Is this the one that just,
Yeah.
or
Yeah,
resigned?
he's going to retire.
Okay.
Yeah, I just wanna know the consistency throughout the district. Once you've adopted that, then all your staff members have to toe that party line of sorts.
All right,
Is that-
let's
is that a
move on to
yes
something
or-
less controversial.
Okay, there we go.
Student discipline. I appreciate your questions and your comments. And, yeah, I mean, hopefully I answered them. And,
I know you always run out of time for presentations, so I appreciate you keeping the topics moving. So.
yeah. So, all right, student discipline, key definitions. So Michigan finally defined what constitutes an expulsion. For the longest time, we didn't know what an expulsion was. So that's 60 days or more out of school. A permanent expulsion is when you're expelled from all public schools. Not just Linden, but all districts in the state. You're expelled from those schools. Suspend, anything less than 60 days. So if you suspend till the end of the school year and it's more than 60 days, that's not a suspension. That's an expulsion. So anything that goes beyond 60 days, that is considered to be an expulsion. Dangerous weapon will be getting into permanent expulsion. So that's why that definition is important. You see firearm, dagger, dirk, stiletto, knife. A lot of those are very sharp devices. A knife has to be over 3 inches in long, 3 inches in length. A pocket knife opened by mechanical, that's your switchblade. Firearm, interestingly enough, is defined as a device that projects a projectile by an explosion. Okay, so it would not include an air rifle or pneumatic gun. You can expand your policies to include air rifles and pneumatic guns as a dangerous weapon, but if you just went with this definition under law, a firearm would not cover a BB gun or an air gun.
Do you know how Neola handles that? I don't-
Yes, they do expand it to cover air guns. Yep. So that should be.
I agree with them on that one.
Yeah. Physical assault, potentially causing or attempting to cause physical harm to another through force or violence. So that definition comes into play with physical assault against a student or physical assault against a staff member. So some key legal principles here that are going to be coming up during this presentation. School districts are creatures of the state, so you only have as much authority as what's been given to you as a school district. And also it's important to know that Michigan provides a free public education to its students. So when you're suspending someone, when you're expelling someone, you're taking away their constitutional right. Okay? So that's a very significant decision in doing that. And then this last statement, Latin phrase, doctrine of statutory construction, wholly expressive mention in the statute. One thing implies the exclusion of similar things, and that's important when we look at admitting whether you're required to enroll a student who's been expelled from another school district. Okay, so keep that in mind when we look at that issue of if a student has divorced parents, one lives in Linden, the other one lives in Fenton, gets expelled from Fenton, can they enroll in Linden? Okay, so think about that, and we'll address that question in a bit. So where do you get your authority from? Starts with section 1311 of the revised school code. This is what I referred to earlier when we were talking about decisions being delegated to the administration. So a school board, school district superintendent, or school board principal, or another school, if designated by the school board. So, in my opinion, that if designated applies to superintendent, building principal, or another school official. So ultimately, the authority for disciplining a student lies with the board, but then it delegates that authority by policy, okay? If a student engages in is guilty of gross or misdemeanor conduct or persistent disobedience, and then if it's in the interest of the school is served by that suspension or order, that student may be suspended or expelled. So that's what gives you the authority as a board to take away a student's constitutional right to a free public education. Okay, the legislature has granted that authority to you, and then you delegated via policy. This section also covers the issue of suspending or expelling a student who commits criminal sexual conduct against another student enrolled in the same district. Now, if that occurs on school campus and it's not a conviction, you can expel that student, okay? If it is conviction, that is a permanent expulsion under law, and we'll get into that as well.
Can I ask a quick question?
Yes.
With some of that, obviously there's statutory limits.
Mm-hmm.
If a conviction happens well after an expulsion,
Mm-hmm.
as a district or as a board, do we have to potentially bring that student back?
I would say no, it automatically become a permanent expulsion.
Or automatic,
Yeah,
so
if it
once
was an
conviction takes
expulsion,
place,
yep.
it's automatic?
Automatic, yep.
Okay.
Yep. Because there wouldn't be any difference in due process. The due process would be the same on that.
Okay.
So an additional hearing would not be required.
Yeah, I think it did.
So some additional authority. So this one comes from the general powers authority that a school district has. Subsection 3 of 11A, where you can adopt policies to provide for the safety and welfare of students while at school or sponsored activity or while en route from school or school-sponsored activity. So this kind of expands your jurisdiction a little bit as a school district to cover those issues that may come up when a student is en route from school or a school-sponsored activity. And then section 1312, the next paragraph there, that requires you to implement a student code of conduct. And that kind of ties into what constitutes the gross misdemeanor or persistent disobedience under this provision. That's not defined, but you define what is a gross misdemeanor in the school district context in your pupil code of conduct, okay? And that is required to be adopted. And that occurs not only at school premises, on school bus, other school-related vehicle, sponsored activity or event, whether or not it is held on school premises. So these are your permanent expulsion laws. So this is a shall permanently expel. Now we're going to talk about kind of exceptions to this a little bit later when we look at pre-discipline factors that you have to consider before suspending or expelling someone. But in this case, if any of this happens, then you shall permanently expel that student. Possessing a dangerous weapon in a weapon-free school zone. Now that's subject to 4 exceptions that we're going to take a look at in a bit. Student commits arson in a school building. That does not require a conviction. So arson would be determined by you folks, what would constitute arson if that expulsion is before the board. Committing criminal sexual conduct in a school building or on school grounds. Again, that doesn't require a conviction. Okay, so that's a permanent expulsion if it happens on school grounds and whoever doing the hearing determines by a preponderance of the evidence that that student has engaged in criminal sexual conduct on school building or on school grounds. Okay, and that would be a permanent expulsion. The next one does require a conviction. Pleading guilty to, adjudicated for criminal sexual conduct against another student enrolled in the same school district. So this does not have to occur on school property. This would be the situation where one student commits criminal sexual conduct against another student off school grounds, and then you could expel under those circumstances, but once it becomes, as Russ mentioned, a adjudicated conviction, the permanent expulsion would kick in. That's when the student can only re-enroll via reinstatement. And then committing a reported physical assault at school against an employee, vendor, or volunteer or contractor. So a student assaulting a teacher or a volunteer. So those are the permanent expulsions. Yes.
So regards to the busing situation, we provide free busing for all our residents in the
Mhm.
district. If there is bad behavior on a bus, what can the school district do to said person as far as, can they suspend them? Is there a length
You can
of
take
time?
away that privilege. So,
You can.
yeah, transportation is not a constitutional right. That's been determined by our Court of Appeals. And if you do offer transportation, you do have to offer it on a equal basis to all students, but it's still considered to be a privilege. So if you abuse that privilege, engage in misbehavior, that can be taken away.
And the district or the board can set up any length of time that it chooses?
Yes,
Or is
yeah.
there
The only issue that could come into play is the student special ed. The student IEP may include transportation, and then that would be problematic, taking away that transportation. Then you wouldn't be able to continue to have the student, further their goals and objectives of that IEP.
But the general ed student, it's not a special needs.
Yeah,
They have the
general
same
ed,
problem.
If they,
They can't get to school either.
yeah.
So what's the
Yeah, so
difference?
that would be, it's not a constitutional right to ride in a school bus. So,
Okay.
that privilege can be taken away. So these are the exceptions that apply to, permanently expelling someone for possessing a weapon on school property. First one, weapon was not possessed as used for a weapon, indirectly or directly delivering to another one for a person as a weapon as well. Weapon was not knowingly possessed by the student. We're gonna look at a court case that addressed that very issue of can you expel a student for not knowingly possessing a weapon when that weapon is on school property. The student didn't have reason to know that the object or instrument constituted a dangerous weapon. That's when a student brings in a knife for lunch, it's over 3 inches long, meets the definition of a weapon, but they didn't know that it was a weapon. And then the last one is, was the student given permission to possess that weapon on school property?
How do you square the length of the knife issue when it's stated in the handbook that 3 inches is considered the maximum?
Yeah,
And so a person brings it in for lunch and it's 5 inches long.
yeah.
How does that
I mean,
square
so
that?
you would apply one of these exceptions, if you do not want to expel that. So the student would have to establish that by clear and convincing evidence that exception applied. So that clear and convincing is a bit more than preponderance of the evidence. So they have to make a pretty convincing argument that yes, I had no idea that was a weapon, I was simply bringing it in to
Big
cut my
sandwich.
steak at lunch.
Okay.
All right, now these are some other discipline laws that could come into play. Physical assault against another student. This is not a permanent expulsion, but you can only suspend or expel a student up to 180 days. So this is a situation where you have to consider how much authority the legislature has given to you as a board. So if you have a physical assault, one student against another, you can't expel that student more than 180 days. The legislature has put a cap on that. Can't go beyond that. Compare that to the next one. A student engages in a bomb threat or similar threat directed at a school building, on school property, or school-related event. You see a limit on that one? No. It's up to the discretion of the school board. And this has been interpreted to mean that you could have a permanent expulsion just in your district for a bomb threat. Wouldn't apply to your neighboring districts, but this would be a permanent expulsion in Linden if a threat was so serious that you believe that student should be permanently expelled, possible to reinstate. So the statement on the bottom is important. School district is not required to allow an individual expelled from this section to attend school during the expulsion. So what that means, if you had a student expelled from Benton from physically assaulting another student, and they have a parent that lives here, you could deny their enrollment during the period of that expulsion up to 180 days. But let's say a student was expelled for drugs over there, and then they want to come enroll here. You'd have to enroll them. Because the legislature in this case has specifically said, we think these are the situations where a school district can deny enrollment to an expelled student. So if they don't say that for drugs, you go back to that Latin phrase that we looked at the beginning, saying it in one area means that it was purposely excluded in another area. So the legislature has, designated those laws where you can deny enrollment, based upon an expulsion in another district. And if an offense doesn't fit into that law, then you have to enroll that student.
Brad, I'm surprised about the 6th grade exception and above. Is a 5th grader not concerned capable of committing a physical assault?
The legislature has determined that a 5th grader would not have the intent to commit.
No matter how big a 5th grader
No
might
matter
be.
how big, yeah. And if you go back to the other permanent expulsion, that applies to an assault against a staff member as well. That only applies to a student grade 6 and above. Now, you could have your own policy. It wouldn't be a permanent expulsion, but you could have an expulsion for a student that physically assaults a staff member or another student, if that student's in grade 4, but it wouldn't be a permanent expulsion.
Jeppin and O'Neill, a stance on that?
I think that could be an option. I'm not sure if they get that specific in their policies. That could be a student code of conduct issue.
We have different language in our policy based on.
You do?
level.
Okay.
Under that, it's 90 days.
All right, so the importance of policy, and kind of, Steve's been emphasizing that, the importance of policy. Indicates who had the authority to suspend or expel students. Who suspends students beyond 10 school days? Now, some smaller school districts, I don't agree with this, but they have anything that goes beyond 10 days goes to the board. To me, that's difficult. You're having a lot of board hearings if that's the case. So generally, that is delegated to the administration. Can a suspension be appealed to the board? Check your policies on that. If your administration suspends a student 50 days, under law, that student doesn't have a right to appeal to the board, but your policies may indicate that. And I believe, I'm not sure, that could be an optional provision under Neola.
Yeah.
Is the administration authorized to expel students or permanent expulsions reserved for the board? That's where the line is kind of drawn, what I've seen for school districts, that the board will handle either all expulsions or just permanent expulsions. So what does your board handle? All expulsions?
Anything
so
over 10
permanent?
days.
And so anything over 60 days?
10.
10 days.
Oh, so 10 days. So you guys are doing a lot of hearings then. Or you don't have a lot of suspended students over 10 days?
Not over 10 days.
Not over 10 days? Oh, okay.
Our code of conduct limits it to 10 days for, and then long-term suspension comes to the board for a policy.
Okay.
Expulsions, all expulsions come to the board for a policy.
Okay, okay. Well, it's good. I mean, that's what you need to clarify
Correct.
in policy. And it's significant to follow that as well. This case, provides an example of a board that did not. You had students that were being expelled for engaging in vandalism. They were caught red-handed. There was no doubt that these students came in and trashed the district's administrative offices, and they were expelled for doing so. But the administration conducted the expulsions, the hearings, and then recommended the expulsions to the board. And the board just approved it. And the board said, well, by approving this, that means the board is actually expelling the students. The court disagreed. Interpreted that policy to mean if it says the board shall expel students, that means the expulsion hearing actually has to be before the board, okay? So your policy has to match practice. If it says the board shall expel or the board shall suspend over 10 days, that hearing has to be before the board. Okay, and if not, it could violate student due process under this case. So this statement here just kind of gives you an idea of how important due process is. This is a quote from a court case. Removal from school has serious consequences for students. deprivation of the right to attend school when a student is accused of misconduct demands the development and administration of procedurally fact-finding, a fair fact-finding process. That's your due process, both substantive due process and procedural due process. Now, you may not be that familiar with substantive due process. We'll talk about that in a bit. You're probably more familiar with procedural due process. That ensures fair and proper procedure. That's your expulsion hearing. Your substantive due process, that is ensuring that whoever is doing the suspending or expelling, they're not making an arbitrary and capricious decision. Okay? They are making a reasonable decision that is furthering a legitimate educational interest. That's substantive due process. So you can't permanently expel a student for chewing gum. Okay? That would be violating the student's due process rights. Certainly, maybe detention, but permanent expulsion for chewing gum, that is an unreasonable disciplinary decision, and that would violate the student's due process rights. So you see, what substantive due process entails. Is there a rational relationship between the offense and the punishment? That's essentially what it comes down to. Are you accomplishing a legitimate educational interest in disciplining of that student? That interest usually is to maintain order or to protect other students. So this is a great court case. I think it provides a great example of what is required under substantive due process when a board goes too far with a zero tolerance decision. So you had a couple of students, they were in a band, and they went home on a Friday afternoon after school and then came back, and their band instructor suspected that they had been drinking alcohol, and they had come back to perform in the band under the influence of alcohol. So the instructor said, I'd like to search your car, and the instructor was able to do it based on reasonable suspicion that he had reasonable suspicion that they were under the influence of alcohol. Searched their vehicle. I didn't find any alcohol, but found a knife in the glove box. The student who owned the car did not put it there. His buddy said, yeah, I put it there. I'm being threatened by my girlfriend's ex-boyfriend. I felt I needed it for my protection. My friend had no idea that I put it in his glove box. So he admitted to it. So clear and convincing evidence that student had no idea that knife was in his glove box. The school district expelled him anyways. Saying zero tolerance, we have a zero tolerance policy. We don't care whether you had knowledge or intent to possess that knife, you're still being expelled. Student claimed that his expulsion violated his rights under the Equal Protection Clause, as well as the substantive due process clause of the 14th Amendment, and the Sixth Circuit Court of Appeals agreed, claiming that was a reasonable decision, violated the student's substantive due process rights. How can you injure someone with a weapon that you don't know you're possessing it? And the court gave the example of someone walking into school and someone slips a knife in their backpack, and they go through the metal detector goes off, and the backpack is searched, they found with the weapon. And the judges asked, are you going to expel that student? And the attorney said, yes, we will. And again, that's a decision that just doesn't make any sense. So the court essentially said zero tolerance doesn't mean zero thinking. You can't hide behind a zero tolerance policy that purports to make knowledge a non-issue. So the takeaway from this case, remember that exception? One of the 4 exceptions, possessing a weapon on school property. Did the student actually have knowledge that they were in possession of that? Based on this case, you have to apply that. So if a student is able to establish that they did not knowingly possess that weapon, you have to apply that exception.
Was the friend that intentionally put the knife in the glove box
Was still
admitted to
expelled.
it for a reason? Was he expelled?
He was expelled, yeah.
And that held up on
Yeah,
his
no,
case?
yeah,
Okay, very good.
yeah. He put it there for use of the weapon.
Sure.
He was going to use it on the other student for protection. So that's substantive due process, and now procedural due process, which you're likely a little bit more familiar with. This is based on the 14th Amendment as well. So when something is taken away, a property interest, liberty interest When that is taken away, under our 14th Amendment, you're required to have process before that's taken away. So Michigan's compulsory attendance law, as well as our constitutional provision on a free public education, that creates a property interest for students in Michigan. And again, in order to take that constitutional right away, you have to provide that student with procedural due process, and this is based on the Goss v. Lopez case. See, that case goes all the way back to 1975, and found that due process applies to suspensions and expulsions. And it did say the amount of due process depends upon the nature of the interest being taken away. So, you know, if there's something of great substance being taken away from someone, more process is due. So that's why you had different procedures for, you know, shorter suspensions and longer suspensions and expulsions. Short-term suspension, so this is kind of a general definition, this isn't a legal definition. So short-term suspension, cessation of educational services, 10 days or less, okay? And this hearing can be done in 5 minutes, and the parent doesn't have to be a part of this. If a student violates a provision in the Student Code of Conduct, that individual can be called into an administrator's office. You give notice of the charges. You show the student, we have a rule on this, you know, no vaping on school property. You were caught vaping, you know, there is a 10-day suspension for that. You have an explanation, you know, why you were vaping in the restroom. Obviously, that's going to be hard to deny. The decision to suspend up to 10 days is based on that evidence. Hearing's done. That's essentially all you need for a suspension that is 10 days or less. That is a rudimentary due process hearing. Again, no notice is required. Advance notice. It's simply notice of the rule that was broken, opportunity to respond, and then the implementation of the penalty. So any questions on that type of hearing? Then we have long-term suspensions and expulsions. So Goss v. Lopez didn't specifically address expulsions or suspensions over 10 days, but essentially said more due process will be required for a suspension that is more than 10 days. So that has been interpreted to mean, we have to provide a full due process hearing when you're taking a student's right to an education away that goes beyond 10 days. So that means written notice of the charges, sufficient time between the notice of the hearing, so you can't send out that notice of a due process hearing at 8 o'clock the night before the hearing that occurs at 7 o'clock the next day. Generally, the best practice is at least having 3 days notice, so the parent can prepare for that hearing. Summary of the evidence, so you provide evidence that will be presented at the hearing to the student and the parent, so they're able to defend themselves. Impartial decision maker, so this is the issue that causes some consternation at times. As a board, if you are the decision maker, you have to be an impartial decision maker. So what that means, you shouldn't be provided all of the evidence in advance, and all the student's discipline history in advance. You should come to the meeting as a blank slate, okay? Because if you got all that information 3 or 4 days before the hearing, you may have your mind made up already before you even hear from the student. And at that point, you're no longer impartial. So, that's why best practice is all the evidence should be presented at the hearing.
Is that the same allowance that the parents should be provided too, or should they be?
No, the parents should be given that information in advance.
How much in advance?
The summary of the evidence. Now, it doesn't have to be all the evidence.
Right.
It's the summary of the evidence that will be provided. That's what due process essentially is.
Several days in advance.
Yeah, at least 3 days in advance. Okay. Yeah. Right to counsel. That could go either way. Best practice on that one. If school district is going to have counsel present, you should give the parents the right to have counsel present. Okay. And then witnesses. And I guess I'm actually going to go into more detail on these in a bit, but just a quick point on witnesses. The student don't have a due process right to know the identity of some of the witnesses. If there's a fear of retaliation against that witness, okay? if you can't have that hearing within 10 days, your administration can have that full due process hearing, but there should be another hearing after that at the board level, if the board is required to have the hearing, okay? So that's the kind of the remedy to that situation where, you know, we can't get a quorum together. What are we gonna do? The student is gonna be out of school more than 10 days. At that point, you have the administration do the hearing, so that student can be out more than 10 days. And then once you get a quorum together, you do the hearing again at the board level.
So when you talk about administration, you talk about like the superintendent meeting with the principal?
Yeah, it could be, you know, it could be just one individual who is the hearing officer there making the decision. So it could be the superintendent doing that hearing, could be a building principal, could be an assistant superintendent. But there should be some full due process hearing before that student is out more than 10 days if you're unable to get a quorum of the board together. So what that notice must entail, we've kind of covered this already as well. Time, date, place of hearing, reasons considered, justification for the discipline, evidence, and then recommended consequences. So
Does that, sorry, back up
Yeah.
real quick. Does that 10 days, is that, if it's done by the administrator because we can't get a quorum, is there another 10-day rule or is it unlimited after that?
it's unlimited after that, but there still should, in order to comply with your policies and to ensure that the student receives due process, there needs to be a hearing at the board level.
Right, but there's no. it
But
could
there
happen like
wouldn't be
2 weeks
another
later.
administrative hearing after that initial hearing.
But it might be 2 weeks before the next,
The next board meeting?
board meeting or something.
Yeah.
That's most,
That would be
sometimes
all
it's,
right.
usually we're able to get together, but sometimes not.
All right, so going into more detail on some of these, so student witnesses I mentioned can remain anonymous due to the fear of reprisal and retaliation. Impartial decision maker, we already talked about that. That requires you to kind of get all the information about the offense at the hearing. Evidence of prior misconduct. This should only be admitted after you determine guilt. So we're going to take a look at the hearing procedures in a bit, but you see, and again, this is what I advise. If you talk to another attorney, you might get a different recommendation, but I think the hearing should be bifurcated, okay? First part of it is determining guilt, okay? Once you determine guilt by preponderance of the evidence, then you determine penalty, okay? And that's when you can take prior discipline history into consideration after you determine guilt. But if you're taking prior discipline history for the purpose of determining guilt, then that could create bias. If the student's a repeat offender, you're thinking, well, gosh, if he did it 2 or 3 times, he probably did it again.
Is it appropriate to include grades as a part of the expulsion hearing or discipline hearing?
I don't think so. I don't think how those would come into play. Preponderance of the evidence standard, so that's more than 50%. So 51% of the evidence says that the student is guilty of what they're accused of doing. So that's much less than the standard of beyond a reasonable doubt. So that's the criminal standard. Okay. And then mention right to an attorney. Some courts have held that when the board proceeds through counsel, the student should have a right to counsel as well. So consider that to be a best practice. That leads us to the pre-discipline factors. So these are relatively new. Have to be considered for every suspension, every expulsion. Okay, whether it's a principal suspending for 5 days or the board permanently expelling, these factors have to be applied. It came into be within the last 10 years, and it provides boards with discretion. Okay, before these pre-discipline factors, if you had a student before you who had brought a knife to school, and this student was being bullied, and had a clean discipline record, straight A student, but the only way this student could bring him or herself to school was to put a knife in their backpack, and then they get caught under the law prior to these pre-discipline factors, you'd have to permanently expel that student. No questions asked. Those 4 exceptions would not apply based upon those facts I presented. Now with these pre-discipline factors, you can consider the student's discipline history. You can consider the age of the student. and you could lower that permanent expulsion maybe down to a 30-day suspension. That's what these pre-discipline factors do. They give you some discretion as a board, but they don't apply to a student possessing a firearm. So if a student possesses a firearm, you don't go through these factors, okay? You still allow the student to try to apply one of those 4 exceptions we talked about, but the pre-discipline factors do not apply. And then if you don't apply these factors, then there's a rebuttable presumption that the student should not be disciplined. And we'll talk about the rebuttable presumptions in a minute. So what are the factors? Again, this is the shall. You see, before suspending or expelling a student, a board, principal, or other designee shall consider these factors. And if you don't consider any of them, if you miss one, then it's a rebuttable presumption that the student should not be expelled or suspended. So the student's age, you take that into consideration, student discipline history, those are kind of the 2 big ones. Whether the student has a disability. So once you are going to determine a student did what they're accused of doing, you do a manifestation hearing for a special ed student to determine whether the offense was related to the student's disability. You can at this stage, based on the student having a disability, lower that permanent expulsion to a 10-day suspension, which may not even trigger the manifestation hearing. The seriousness of the violation or behavior committed by the student, that should be a consideration. The threat and the safety of another student or staff member could restorative praxis be a way to address this behavior. We'll talk about restorative praxis in a minute, and then when a lesser intervention properly address the violation or behavior. So, all these need to be considered, and you should be checking them off as you go along prior to suspending or expelling that student. So, this rebuttable presumption, if you don't do one of these factors, then you have to overcome the rebuttable presumption that this student should not be suspended or expelled. Is there some type of additional evidence that you can use to overcome that presumption? However, and then the rebuttable presumption also applies with possessing a weapon. If the student is applying one of those 4 exceptions, possessing a weapon on school property, that's not required, okay? But if you don't apply that, then there is a rebuttable presumption that the student should not be permanently expelled if they're able to establish one of those exceptions in a clear and convincing manner, and then the student has no history of suspension or expulsion, okay? A quick example on that, I'd say it's almost about 20 years ago or now, Hope School District had a situation where the student dressed up in full Scottish regalia to the prom, okay? And the administration knew that he was going to wear that little knife in his sock. That's part of the Scottish regalia, and that knife constituted a weapon. And the administration said, don't wear it. And the student said, well, I'm not using it as a weapon. It's part of my outfit. And I feel like I can't dress in full Scottish regalia without it. So he still goes to the prom with that knife, and he ends up being permanently expelled. Now this was before the rebuttable presumption requirement that would come into play. So would come into play. So if that were the case today, he would be able to show that he wasn't possessing that knife as a weapon. It was part of a decoration. So he was able to establish by clear and convincing evidence that it was not being used as a weapon. And if he had no history of suspension, then the whole school board would have to overcome that rebuttable presumption of him not being subject to expulsion. And how they could have overcome that would have been, we told him not to wear it. Okay? Now, if he had shown up without being told not to wear it, then maybe they wouldn't have been able to overcome that rebuttable presumption. But the fact that he was told in advance not to wear it, to me, that would still give them the authority to expel the student, overcome that rebuttable presumption that would be created based on those 2 factors. Restorative practices, you guys use restorative practices at all?
Yes.
You do? Okay. So required by law to at least consider using restorative practices?
Yes.
Yes?
We actually have entire buildings, middle schools all
Oh.
We also have 3 staff members that are educators, 1 social worker, 2, a social skills facilitator and teacher going to be training the trainers model this summer.
Wow.
And a new administrator who's also a trainer.
Wow, that's great.
Yeah.
And that's what you gotta do with restorative practice. You can't be like just one foot in the water. I mean, you either gotta be all in or all out, because it just doesn't work if you're not totally invested in it through professional development and, getting all your staff engaged. So, yeah, credit.
Other buildings are
you're-
doing it. It's really great, honestly. It's making a huge difference on some of the discipline that may have been more punitive in the past.
Yeah, and I think that says volumes based upon not many of those more than 10 days suspensions coming to the board. So under law, just so you know, restorative practices shall be considered. Now, you're not required to apply restorative practices. It's just a recommendation, but you must consider them, as far as using in the place of a suspension or expulsion, or in addition to a suspension or expulsion, or use exclusively if you decide not to suspend or expel that student. It has to be the first consideration to remediate interpersonal conflict, bullying, verbal and physical conflicts, but it generally doesn't apply to those more serious offenses such as a sexual assault or possessing a weapon. So the motion to suspend or expel. So back in the day, when I first started, when you expelled a student as a board, you identified that student by name. It may seem odd nowadays, because you think, well, that's a clear violation of FERPA. Well, back in the day, we didn't think so. And there was a Michigan court case that actually required a board to identify a student in its motion and in the minutes when that student was expelled or suspended by the board. And this kind of goes to what's going on today. Michigan, meaning we, received a letter from the federal government saying, Michigan, you're violating FERPA with this statewide practice of identifying students that have been expelled in minutes. And if you continue to do that, you're going to lose federal dollars. So as a result of that letter, Open Meetings Act was amended in 2004 to prohibit school boards from including personally identifiable information in your minutes and in a motion when you're suspending or expelling students. So what this means is you have to be very careful when you're in open session discussing a student discipline matter. You shouldn't release any identifiable information. It becomes a little bit wonky, and I don't know if you've ever had to deal with this, where you've had a parent actually request open student discipline hearing, and that never happened. So if that happens, even though everyone knows who the student is, you still are using anonymous identifiers to address that student. Because the parents can, release all that personally identifiable information, but the board is still bound by FERPA under those circumstances. So you would refer to the student as student 2025A or something along those lines. So when that happens, it gets a little bit odd. And that brings us to reinstatement. So reinstatement under law only applies when a student has been permanently expelled, okay? And I find a lot of school boards, a lot of school districts misinterpret reinstatement. They think any student that has ever been expelled must be reinstated, and that's not the case. You go back to the law on physical assaults against a student, you can only go up to 180 days, right? So if you expel a student for 180 days for assaulting another student, you can't require that student to go through the reinstatement process. You don't have the authority to do that as a board. So reinstatement generally applies to those permanent expulsions. A student, in order to be readmitted, must apply to the expelling district first. And if they're going to be enrolling in another district, they still have to apply to the expelling district first. They get denied in that district, then they can apply for reinstatement in that enrolling district. You can include a behavior contract that makes the reinstatement conditional, that in order for the student to be reinstated, they have to do these steps to ensure that they're going to be a safe student when they are re-enrolled back in school. The process is outlined in the law. It is reviewed by a board committee. The board establishes that committee. It should be in your board policy. This is, again, dictated by law, 2 board members, 1 school administrator, 1 teacher, 1 parent of a student in the district. That is your reinstatement committee. The board is not required to assist the parent with submitting that application. That's the parent's obligation. And then the committee makes a recommendation to the board. Unconditional reinstatement, conditional reinstatement, or against reinstatement. And then it must be based upon a number of multiple factors. You see what these entail. Very similar to the pre-discipline factors that we previously looked at. And then the final steps, the board must make a decision on reinstatement. Okay? And it has to be done at the board meeting, at the board's next meeting after that reinstatement committee. And then that student may be enrolled, but the board doesn't have to reinstate a student. That's why they're referred to as permanent expulsions. If the student is not reinstated, then that is permanent. So before we get on social media, I just kind of wanted to wrap up student discipline. You should have the handout on the hearing script. Just wanted to quickly cover that.
The composition of the board reinstatement committee is established by law. And
Established by law.
must be in your board policy.
It would be in your board policy.
It must be in your board policy.
Well, it's established by law, so technically it doesn't have to be in your board policy.
It doesn't have?
That doesn't have to be. I mean, instead of going to your policy, you can go to the law and see where it says, has to be those numbers on the reinstatement. But it's probably in your policy. All right, the hearing script. So this is kind of like a tool for your presiding officer on having a student discipline hearing. And you start out by asking those questions. As you can see, a lot of those questions are related to due process. And you explain the process to the student that the administration will present the charges and the evidence first. And then after that, the parent can defend against those charges. So you conduct a hearing, and the script indicates you want to make sure that the parents did have advance notice of the evidence that was going to be presented at the hearing, so they are able to create an argument to respond to that. Now, the question comes up frequently, can the board deliberate in private? So the parent has requested the closed session, right? Under Section 8A of OMA. Can the board ask the parent to leave? And I believe they can. If the parent demands to remain, you say, okay, you can stay, but you can ask them to leave. But if you're asking the parent to leave, you should have the administration dismissed as well, okay? Because what you don't want is what's called ex parte evidence, where maybe someone asks the administration a question and they say, oh yeah, I forgot about that, this, and this happened, and that evidence is presented without the parents being present, and they don't have the opportunity to respond to that. So to ensure due process 100%, you want to make sure that if you're dismissing the parents, you also dismiss the administration. Then you can deliberate in closed session. You can't make a decision in closed session. If you've gone through my Open Meetings Act class, you know that. And then you go into open session, and that's where you vote on whether the student did what they're accused of doing. So that's the the guilt part of the hearing. And you can see how that resolution reads. And then after you determine that, you go through the pre-discipline factors, because the pre-discipline factors have nothing to do with guilt. Once you've established guilt, then you go in to determine, okay, what the penalty is going to be. And that penalty will either be dictated by law, policy, or your student code of conduct. And you could go below that based upon those pre-discipline factors, okay? You can't really go above what is permitted under law, permitted under your student code of conduct, because then that would violate their due process rights. But you can go below what is in your policy and student code of conduct or the law based upon these pre-discipline factors. You see the bullet point on considering restorative practices. You can convene back into open session if you're going to be disclosing any personally identifiable information. Then after you consider those factors, then you vote on the resolution for the disciplinary consequences. You can see what that entails, and I kind of put in a provision there that refers to restorative practices as well. So that's the script. Any questions on that? Hopefully you find that to be a helpful tool for your next student discipline hearing. That brings us to board member social media. Board members using social media. So the first thing you should look at to address this issue is your bylaw. So, you guys have Neola. Neola has a standard bylaw, 0167.6, social media, as defined in the bylaw definition, shall not be used to conduct any form of board business. So the question I get when people look at this policy, what is board business? And to me, that is up for you to decide as a board. When someone has crossed the line of conducting board business via social media, my thought is, I think the intent of that policy is don't use social media to violate the Open Meetings Act. I didn't write the policy for Neola, but I believe that's the intent of it. So I would say conducting board business would mean trying to conduct business under the Open Meetings Act via social media, which you can't do, which would be an Open Meetings Act violation. That's how I would interpret that. Then also you have this statement here in bylaw 0143.1. Use of social media may have unintended negative consequences. Refers to the Open Meetings Act. So just be responsible as a board member, ensuring that you're complying with district policies in the use of social media. This is just a quick slide on possibly violating the Open Meetings Act using social media. Just be careful with that. If you look at the definition of a meeting, right? 4 board members deliberating on school district business. If that happens on a social media platform, that's a violation of the Open Meetings Act. So best practice, I'm going to recommend that board members should not use social media as a vehicle for communicating with each other outside of a board meeting. Okay? You can call that person, have a conversation with that person on a one-on-one conversation, but once that conversation on social media, you just don't know how it's going to be disseminated. It could eventually get out of your control of how that is being disseminated.
And also, any conversation you have with a fellow board member, you can't say that I also had the same conversation with other board member and they said this.
Yeah, so
Start dragging them all into your conversation with a different board member.
what you're referring to is creating a constructive quorum or splintering the quorum. That is when you have separate sub-quorum meetings that attempt to circumvent the Open Meetings Act by not having a quorum physically present at one location. So if a board vice president and board president meet with board member A, and then they meet with board member B, and then board member C. Neither of those meetings have a quorum of the board, but then information is shared amongst those 3 mini meetings. That's creating a constructive quorum that would violate the Open Meetings Act.
But I could call 3 fellow board members and say, what do you think about this? Without telling them.
Yeah, so you can always canvass, other board members. I use the example of electing officers. So I want to nominate Brad for president. I don't want to nominate him unless he's going to get elected. So you can go down and count your votes. You contact Rachel, you contact Rebecca, and you contact Mary Jo. See where your votes are at. And if you get 4 votes, then you can nominate Brad for president, knowing that he's going to get elected.
Or not.
Yeah, or not. Well, if I count it, I guess they can always change their mind, right?
Well,
They're not committed to that.
We could just put it
Then
on
I would
record.
be mad.
We can just put it on record.
Yeah.
You're interested in being president.
So FOIA and social media, if you're using social media as a board platform, your communications on that social media may be subject to FOIA. That's what this case is about. It involved a mayoral candidate of Livonia, and this person was eventually elected as mayor, and someone made a FOIA request that she had established for her election as mayor. So that request was rejected. The individual filed a lawsuit claiming that should have been a public document subject to FOIA, and the Court of Appeals, based on this definition, that the public body is retaining that record in the performance of an official function, that was not a public record because it was on a personal page and the records were created while that person was running for mayor. Now, if that mayor were to use the profile, Facebook profile, for purposes of performing her function as a mayor, then those messages would be subject to the Freedom of Information Act as a public record. So that's kind of where the line is drawn. That brings us to this last issue on social media. So this case went all the way to the US Supreme Court, started here in Michigan. We'll get the case in a minute, but it involves whether you could violate someone's First Amendment rights if you block them from your social media page, or you delete comments by that person from your social media page if you're using social media as a platform for your school board position. And what courts look at, are you acting in an official capacity in administering that social media page? So does Linden have a social media page?
We have a district.
You have a district page?
Yes.
Okay, do you allow comments or is it just one-way information?
It's one-way information.
Okay, and that's the best practice.
No, it's not.
It is? So you allow comments?
Okay. No, we allow comments.
You allow comments? Okay. So what if, halfway through the football season, your coach is struggling and people start criticizing the coach on social media?
Yep.
And you take down those comments?
I'm just double checking.
Yeah.
The good thing is, they
That
don't
would
do
like-
that on
We do
our
have someone
official
who
page,
monitors
they do
it.
that on the unofficial page.
Yeah.
Yeah.
So it's not on the district, yeah.
I've
So
never
you-
heard that thing there.
So if you allow positive comments on your district page, you would have to allow negative
Yes.
comments as well.
Yes.
So you really have to be very careful on what type of comments you censored or whether you blocked an individual. Because clearly a school district is a state actor for the purposes of the First Amendment. That's undeniable. But the issue is a school board member, could a school board member be a state actor if they have a social media page that relates to their position on the Board of Education? And that's what this case entailed. It involved a city manager from Michigan here, and this happened during the COVID situation, and he used his personal social media page to kind of highlight different things he was doing as a city manager. And an individual was being highly critical of some of the decisions that the city was making during COVID, and he blocked that person. And then that person said, well, you can't do that. This is a city-related page, and that would be violating my First Amendment rights if you were to block me from participating on that page. And this case went all the way up to the US Supreme Court, and the Supreme Court set a rule for all public officials to apply. So even though this involved the city manager, applies to school board members as well. So does the board member possess actual authority to speak on the school district's behalf? And are you purporting to exercise that authority when you're speaking on social media? If you meet those two elements to this rule, you need to be extremely careful with how you administer your social media page, okay? So in most cases, it's the board president that I think has to be the most careful if you're using social media as a platform for your school board position. Because the board president has a little bit more authority than other members on the board. You can contact legal counsel, you can schedule a special meeting. So there are some cases where you could be engaging in school board authority while on social media. But an example that I like to give that isn't an example of engaging in a state action would be, let's say you're gonna cancel school and your superintendent contacts you to give you a heads up. I'm canceling school today, just wanna let you know I'm gonna send out the notice in 5 minutes. But before the superintendent's able to put that notice out, you get on social media and say, school's canceled today, as a board member. You share that information, and then people aren't happy that school is canceled, and you get all these negative comments, and then you start taking those off your social media page. Are you violating the First Amendment rights of those students? In that case, no. Because as a board member, you don't have the authority to cancel school. That's the superintendent's call, not an individual board member's call. So in that case, you're not exercising authority on behalf of the district. You were just sharing information that was being passed along to you. Yes?
Would it be more appropriate to reflect that the board president's, it's not an authority, it's a responsibility to the board?
I'm sorry, I'm missing your point.
Authority seems to be implying that like you've got like extra powers.
Yeah, so I mean.
Well, they are the communication voice for the board.
Yeah,
They're
and
not
that's
the
board president.
creator of communication.
I mean, but your policies likely indicate that the board chair is the spokesperson for the board.
Right.
But that's a responsibility, not an authority.
I think you delegated the authorities to the chair to be the spokesperson for the board. We could disagree on that, but
We will.
that's how I interpret that. So takeaways from this court case, categorizing posts that appear on an ambiguous social media page, very fact-specific undertaking. You look at the content and function; those are the most important considerations. You know, the best if you're using social media to kind of put yourself out there as a board member, you should clearly indicate that this is a personal social media page. I am not acting on behalf of the board. That would be helpful, but still, if you're in a position where you have authority to make a decision and you purport to use that authority out on social media, you know, that's when you likely cross the line, and you'd have to be very careful on who you censure or block from your social media page. Again, my best practice is always going to recommend, you know, keep social media and your school board position separate. That's, I think, the best case scenario. Yes?
So do you suggest that as an independent school board trustee, because I'm just thinking about other districts, I see some drama sometimes. They have their own Facebook pages and it says, I'm a school board official for this school district, not official, all opinions are mine.
Yeah.
But it gets pretty dicey on there, and there'll be heated topics and they'll throw their opinion out. Do you think that maybe boards, I mean, you can't deny a First Amendment right, but we should just say, don't put on this page that you are a school board member trying in that capacity. Even though you say it's my opinion,
Yeah.
the community doesn't think it's.
Yeah,
just
people
opinion.
would likely misinterpret that.
Yes.
I think, but the purposes of this case, I would say that still wouldn't be the board member engaging in a state action for the purpose of the First Amendment, but it still could be subject to FOIA, those communications, even though that individual board member, you know, doesn't maybe have authority to act on behalf of the board and putting things on social media and making announcements or declarations. I think you should always be careful as a board member when you're on social media.
I decided not to have one because I seen what's happening in some other districts and I said, wow, that's a mess.
Yeah, it does create some drama for sure. All right, well, we got a perfect timing here. I think we'll get finished up right at 7 o'clock. So, boards, we're going to get into roles and responsibilities here. Legal duties. So, the school code has a general powers provision that gives you broad authority on the Board of Education. All right, school code used to be very specific and directive. That's no longer the case. You have this broad general powers authority, so you can adopt policies, practices that relate to all these legal duties. Educating students, that's obviously the big one, right? Most of your policies relate to educating students, but you have policies on providing for the safety and welfare of students as well. One case that looked at that second bullet point was a case where a school district adopted a no peanut school, where you had a student with a very severe allergy, and the board passed a policy that there would be no peanut products in that school because of that student's allergy. A parent came back and challenged that, said, you're infringing upon my rights as a parent by adopting that policy, and you're violating the school code by doing so. The court looked at that and pointed to that second bullet point. Now, in this case, the district's general powers authority providing for the safety of students overrides or supersedes your right as a parent to send your child to school with the lunch of your choosing or the snack of your choosing. So you are subject to that anti-peanut policy, and that doesn't infringe upon your rights as a parent to direct your child's education. So court looked at that issue and sided with the school board under its general powers authority. So you see some of the other function there: acquiring, maintaining, disposing of property, determining personnel matters. We'll get to that issue in a minute. Making joint agreements, cooperative agreements. That's kind of the lesser known used authority under that provision. So some very specific provisions in the school code. You have to adopt bylaws. Have to have a monthly regular meeting indicating those bylaws. Required to employ a superintendent. That is a requirement of the school code. Michigan used to be a civics-only state. That's no longer the case. Now you have some pretty stringent graduation requirements that your curriculum must follow. Hiring of teachers, and you have teacher contracts. even though the board's not involved in that hiring process, the teacher is still approved by the school board under the school code. We have evaluation requirements now. Obviously, the board's involved in that, evaluating the superintendent, competitive bidding requirements for supplies and construction projects, and then criminal history, criminal record checks for any employee. Anytime someone is hired by a district, they have to go through that criminal history, criminal background check process. Does not apply to volunteers though. That's a local policy issue. So that's up for a district to decide, that if you're going to have a volunteer go through a criminal history or ITRAC check, that is a local decision, not required by the school code. So your legal authority, you operate as a collective body, not as individuals. So individual board member has no more authority than their next door neighbor who doesn't serve on the board. So board acts as an entity, and that's kind of memorialized here in section 1201 of the school code. That's how a board legally acts. Majority vote of the members elected to and serving on the board. Has to be at a meeting and a proper record made of that vote. If you don't meet those three elements, the board hasn't legally acted. So an individual, can't make a board decision unless the policy allows that individual to make a board decision. That's very rare. Okay? Like I said, a few examples: the president calling a special meeting, maybe the president being authorized to contact legal counsel, but very rarely can an individual board member take action on behalf of the board. Your policy making, this is your major function as a school board, foundation which the district is built on. Spell out how your districts operate. The policy is carried out by the administration and the administrative rules. Just like we talked about earlier with the executive branch and the legislative branch, same thing at the local level. You adopt policy, administration carries out those policies with rules. Administration doesn't have the authority to adopt policy. Anything the administration does has to be related to a policy, okay? Or they have to have that individual delegation under law. But if it's not under law, there has to be some type of relationship to a policy. Financial resources, board's responsible for adopting a budget. We have that coming up here soon. That's dictated by the Uniform Budgeting and Accounting Act. Required balanced budgets under that Accounting Act, but it does say there is an exception if you have an appropriations law that allows for deficit budgets, then you can follow that appropriations law, which we have in our state aid act. You adopt a deficit budget, you have to file a deficit elimination plan. So while the Uniform Budgeting and Accounting Act says you have to have a balanced budget, state aid act gives you an exception to that. But you can't have any spending without prior authorization. So that's why you have all your budget amendments. With the uncertainty of school funding and how many students you're having, not uncommon to have budget amendments. Because right now the state might not even have its budget approved when you're approving your budget in June. So it's kind of a crapshoot. And then staffing, the responsibilities, delegate the recruiting, recommending, evaluating, promoting, disciplining of staff, according with policy to the superintendent. Board is involved at the high level, negotiating parameters, salary schedules, terms and conditions of employment, fringe benefits, and leave. Major policy issue here, dealing with a school district where the administration did not reappoint a gymnastics coach after 40 years. This coach had been coaching 40 years. The administration had a number of issues with this coach. The coach had become bigger than the program. The coach thought she was bigger than the school district, and there were problems, and eventually the administration said, we're not inviting back. Policies allowed that 100%. And now there's an uproar in the community, and the community wants the board to do something. Board member contacted me. I said, you delegated that to the administration. Anything that you do to intervene in that decision, you're acting contrary to policy. So that's why policy is so significant. You just, again, and you mentioned this, Steve, that you should be aware of what Neola is recommending to you as a board.
Recommended.
Yeah.
That's an important
It
word.
is recommended. Yeah.
Recommended.
You don't have to adopt it.
We need to know what's required by law and what's a recommendation of Neola. That's
And-
where I wish that Neola would break that out in their Neola policies to us.
Well, I think
This is
that's where
state
your
law.
associate.
This is
Your
recommended.
associate should be able to assist with that.
Our
issue.
associates?
Yeah, Neola associate.
Oh, our
person, our liaison?
Yeah, yeah.
Okay, why don't they just write it out as a matter of fact in the policy?
I don't.
Just they can color code it, this would be law, and this would be
You know what?
suggestion.
We have a relationship, I will recommend that to you.
Thank you.
Yep.
All right.
And that's it, 7 o'clock. That's pretty late.
Right on the button.
Yes. All right, so again, you saw my contact information. Any follow-up questions, don't hesitate to send an email, give me a phone call. I'm gonna be busy tomorrow morning doing an executive assistance workshop, but anytime after that would be fine.
Well, thank you very much, Brad.
You're welcome.
I appreciate you coming, I know we all do. A lot of really good information, good reminders, good, knowledge for maybe newer board members. I feel pretty good about how we've been doing things. I
Mhm.
think everything you presented is very much in alignment with, how Linden handles things, so that makes me feel good as the board president. Should make us feel good as a board, I think, so, thank you very much. Mrs. Keller, we don't have any public comments this evening?
I do not.
Okay.
Nope.
And with that, at 7:01, we'll be adjourned. Oh, gosh.
Yeah, I don't stand up. Thank you very much, sir. I really appreciate you coming in. Yeah, perfect, yeah. Well, yeah, I don't expect, yeah, but I'm, thank you. Yeah, I do.
Yeah,
Every day.